Thank you, Madam Chair. The first procedure will be for everyone to introduce themselves. So that'll be the officers, the applicant and the relevant representations. The members will then be asked to make any declaration of personal or prejudicial interest. The licensing officer will then present the report, which hopefully everyone has had. At that point, there'll be opportunity for members of the committee to ask any relevant questions to the licensing officer. The other persons will then be invited to ask for any clarification in respect to the report presented. So after the members have asked their questions, then any points of clarification from the other parties will be invited. The representations opposing the application will then be read out. The members will then be invited to ask any questions to those in respect to the relevant representations. And then the applicant can ask questions of the representations at that stage. And then after that, the applicant themselves can present their application, and then questions can be put by the committee members and the representations at that stage. And then at that point, the applicant can sum up in closing submissions any issues they wish to address. Thank you, Chair.
Thank you very much. So, as I said, I'm Councillor Penny Matthews. We're going to introduce ourselves so we all know who we're talking to. On my right, we have Councillor
Victoria Holland.
And on my left,
Councillor Leslie Walton.
and taking us round the room.
Aled Griffith, Legal Advisor.
Good morning, Samantha Woon, Democratic Services Officer.
Yvonne Lewis, Team Leader for Licensing.
My name is Bill Parry. I'm the solicitor for the applicant today. I have two very nervous gentlemen on my right-hand side. The first is, they're both Mr. Al Saab. Bear with me, I've got notes here. The first is Mr. Imad Al Saab, who is a director of the applicant company. His son, Omar Al Saab, is also here. I think he's observing rather than anything else. I should tell you that Mr. Al Saab was born in Iraq. His English, in my view, is pretty good, but he's very nervous and very concerned that he's not going to understand anything today. So I'm rather hoping that his son might help if we find ourselves in that difficulty. But I hope we won't. Thank you.
Hi there. My name's Barry Davis. I'm Director of Asprey Planning, and I'm here representing 5 business owners on Wine Street. I'll allow them to, the two gentlemen on my right, to introduce themselves.
Mr. Yilmaz for the 2 business in Wine Street, 61 and 62 Wine Street. So, Mr. Yilmaz for 61 and 62 Wine Street, 2 business I own that.
My name is Hamid Esfahani, owner of the number 7 Wine Street, Swansea Kebabs.
Prejudicial interests in this case? No, no, there are none. So we set things up now then by going to the officer who, as they've explained to you, will go through the papers, explain what you've applied for, and we'll take it through the process from there.
The premises is Flame Kebab House, 11 Wine Street, Swansea, SA1 1DP, and the applicant is Flame Kebab House Limited. It's an application for a new premises licence, was received by this authority on the 9th of May 2022. The applicant has applied to allow the following licensable activity to take place. That's late night refreshment, Monday to Sunday, 2300 hours to 0500 hours, and the opening hours are Monday to Sunday, 1600 hours to 0500 hours. A copy of the application and plan is attached at Appendix A and Appendix A1. Appendix A is page 6 to 25 of the application pack, and Appendix A1 is page 26. The venue is situated on Wine Street, Swansea. There are mostly commercial properties along this street. However, there are residential properties, mainly apartment complexes, situated along the upper levels of the street. Many of the commercial properties have premises licenses, which allow several licensable activities, including the sale of alcohol, regulated entertainment, and late-night refreshment. However, some just have late-night refreshment. Wine Street is an area known for its vibrant nighttime economy, with student night on Wednesday and Friday and Saturdays being the busiest evenings. The applicant seeks to open a late-night refreshment premises selling hot food and drink. Although opening at 1600 hours, the premises requires a premises license to remain open after 2300 hours, selling hot food and drink, and proposes to trade between the hours of 2300 hours and 500 hours, with the benefit of this license if granted. The premises at 11 Wine Street had the benefit of a premises license which allowed the below licensable activities, which was issued in 2014. The premises was known as Tino's. It had performance of live music Monday to Sunday, 1100 hours till midnight. Recorded music Monday to Sunday, 0800 to 0100. Late night refreshment Monday to Sunday from 2300 hours to 0100 hours, and a supply of alcohol Monday to Sunday, 0800 hours to 0100 hours. This license lapsed on the 13th of July 2019, and the premises has remained empty. There are several other late night refreshment licenses along Wine Street, some of which are held by premises offering other licensable activities, including the sale of alcohol. The premises related to this application on Wine Street, which have only late night refreshment as a licensable activity with no sales of alcohol, are listed on Appendix B, and that is page 27 and 28. The location of Flame Kebab House in relation to the business addresses of those who are represented in the submitted representation can be found on a map at Appendix C, and that is on page 29. On the 30th of July 2013, the Council resolved to adopt a cumulative impact special saturation policy for the following areas: Wine Street and the surrounding area, Kingsway and surrounding area, High Street and College Street. However, due to the COVID pandemic, the consultation assessment as to whether the policy should continue was not conducted within the required time limits, and therefore no regard can be given to Section 6, the cumulative impact and special policy within the Swansea Statement of Policy for Licensing. The absence of a CIA, however, does not prevent any responsible authority or other person making evidence-based relevant representations on a new application for the grant of an authorisation on the grounds that the premises will give rise to a negative cumulative impact on one or more of the licensing objectives. The Licensing Act 2003 contains 4 licensing objectives, namely prevention of crime and disorder, public safety, prevention of public nuisance, protection of children from harm. Each of these objectives is of equal importance, and the application must demonstrate how they are to be promoted. Conditions consistent with the operating schedule and will be attached to the licence if granted, as applied for, are attached at Appendix D, and that is on page 30 and 31. Relevant representations. There's a list of the responsible authorities and there were no representations submitted from them. Other persons, a representation submitted by Mr. Barry Davis on behalf of 5 nearby business owners. The representation and clarification emails are attached at Appendix E 1 to 5, and that is on page 32 to 42 of this pack. Additional information has been submitted by the applicant's representative and is attached at Appendix F, page 43 to 67. Further pictures have been provided by the applicant and circulated. These are pictures of the interior and exterior of the premises. Guidance issued by the Home Secretary. Members should also have regard to the relevant parts of the current statutory guidance issued by the Home Secretary in April 2018. In particular, Introduction, Chapter 1, Licensing Objectives, Chapter 2, the application for a premises license, Chapter 8, determining applications, Chapter 9, conditions attached to a premises license, Chapter 10, and the statement of licensing policy, Chapter 14. And the link to the guidance has been attached to this report. Determination of the application. A decision must be based on the individual merits of the application and the representations received with a view to promoting the licensing objectives outlined in paragraph 5 of this report. In arriving at the decision, members should have regard to the relevant provisions of the policy and the guidance as previously provided. Reasons must be provided for any departures from the policy or guidance. In reaching the decision, the committee must have regard to the representations, take such steps mentioned below, if any, as it considers appropriate for the promotion of the licensing objectives. A, grant the license subject to conditions that reflect the operating schedule, modified to such an extent as the authority considers appropriate for promotion of the licensing objectives. And B, point 2 is any mandatory conditions relevant to the license. B, exclude any of the licensable activities to which the application relates. C, refuse to specify a person in the license as the premises supervisor. That is only relevant for applications for alcohol sales. And D, reject the application. The licensing subcommittee's instructions are requested.
Do you have any questions? Do you have any questions of the officer? No. There are no questions for the officer, so no.
Chair, if there are any questions from the relevant, the interested persons or the applicant themselves. Or the licensing officer.
No, I'm guessing I can, as I make my representations, questions can be asked within that. Is that correct?
It can be. I mean, if there's any point of clarification you wish on the report at this stage, then it may be appropriate to ask them now. If alternatively you wish to make representations at the appropriate time, then that'll be your opportunity at that stage.
I'll do it then, if that's okay. Yeah.
So, Mr. Davis, now is your opportunity to speak on behalf of the representations.
Right. Thank you, Chair, members, and officers. I'll try and keep this brief. But as you're aware, and as noted by Charles, on the 30th of July 2013, the Council resolved to adopt a cumulative impact special saturation policy for the following Wine Street and surrounding area within which this property lies. The special policy was reviewed as part of the review of the Statement of Licensing Policy undertaken in 2018, and it was agreed that the cumulative impact policy needed to remain in place. The cumulative impact policy does make certain exceptions for premises which may not add to existing cumulative impact. But in respect of all other premises located in the special policy areas, the policy, which has been approved and updated by the authority, is very clear that, and I quote, there is a presumption that any application for a premises license, a club premises certificate, or a variation that is likely to add to the existing cumulative impact will be refused. This is exactly the case at hand here, where the application made for a premises license at Flame Kebab House does not meet any of the exemptions set out within the cumulative impact and special policy.
Can I ask one question, Mr. Davis, before you proceed any further? The licensing report confirmed that the policy has lapsed. My advice to the committee will be to treat the application as if there is no cumulative impact policy in place. Now, that doesn't prevent you making representations on cumulative impact. That is still allowed. However, the legal basis will not be that the application will be refused unless the applicant can show that the burden of proof is now a standard licensing burden of proof where there is a presumption to grant unless the relevant representations give cause for concern that the licensing objectives aren't being promoted.
Thank you. Well, perhaps I can seek some clarification on that then, because
certainly,
as you've noted, the committee papers, they do indeed suggest that the CIP policy has lapsed, and the reasons given were that it was not reviewed on time due to the COVID pandemic, and thus no regard can be given to Section 6 of the licensing statement. But paragraph 1.3 of the licensing statement states very clearly that the policy will remain in force until revised in accordance with the Act. Paragraph 3.2 of the policy further states the policy will be kept under review and the licensing authority will, if necessary, after appropriate consultations, make such revisions as it may be considered appropriate.
Yes.
Any amendments will be incorporated in the licensing statement after each review. More importantly, Section 5 and Section 5A of the Licensing Act are quite clear that where revisions are made to the licensing statement or to the CIP, respectively, the licensing authority must publish a statement of the revisions or the revised licensing statement or the cumulative impact policy. Could officers therefore advise when the council consulted on the effective revocation of Section 6 of the licensing statement, and could we be enlightened as to when this committee debated, voted and approved a decision to revoke Section 6 of the licensing statement?
My advice has been that Section 5A, which was brought into force by I think the Police and Criminal, I'm not sure exactly the name of the Act, of 2017, it brought in a new Section 5A, which required it to be reviewed every 3 years. And in order for that cumulative impact area, as it's now called under the 5A, to be re-established, reaffirmed, it had to be done within the 3 years, and that consultation process had to take place. Now, my advice has been that if that isn't undertaken, then that policy is no longer valid.
Well, I would ask, where in the Act does it say that if the review is not undertaken, that it's revoked? It simply doesn't state that. There is no power to revoke Section 6 of the cumulative impact policy unless there has been appropriate review undertaken in accordance with the Act.
Well, the terms of, I'm just bringing the appropriate section up now. In my view, in order for it to carry on, there are certain steps that must be taken. And that requires evidence based on the consultation that has to be carried out within 3 years. If that evidence isn't in place, then the evidence isn't there to continue that policy.
But on the contrary, the evidence isn't there to discontinue that policy, which has been reviewed multiple times.
But the onus is on the licensing authority to maintain that status quo and maintain that cumulative impact assessment based on evidence they have. If that evidence isn't there, there's no evidence even to keep the cumulative impact area ongoing.
But what evidence do you have to the contrary to suggest that the cumulative impact policy should not be effective?
Well,
there is nothing in the Act that says a failure to review, which, let's be honest, is a failure of the authority to do that review. That does not mean that the policy should fall away. The Act simply does not say that.
No,
and our view is, therefore, in order to amend the licensing statement or the cumulative impact policy, the Act is very, very clear. There has to be certain steps undertaken in order for that to happen. So it cannot simply be revoked.
But no, it doesn't. It's not revoked. It
or disapplied.
Expires is what is the appropriate word.
The licensing statement does not say that, and neither does the Act say that.
My legal advice has always been, if that step isn't carried out, it falls away. And now I appreciate that there's a dispute here, and that might be a dispute for a higher court. But my advice to the committee will be that if that step is not taken, because it places a positive onus on the authority to re-justify the existence of a policy, then without that evidence isn't there to maintain that policy.
Which begs the question, did you disapply the CIP when you failed to review within 3 years after it was brought in 2013?
Well, it's not even a case of disapplying, it's a case that it naturally falls away, it naturally expires.
So did it expire at that point as well?
It would have expired in 2021 after the 3-year review that was conducted in 2020.
But there was a, if my timings are correct, it was brought in 2013, but then wasn't reviewed until 2017.
2018, but at that point, Section 5A wasn't in place because the 2017 Act was what brought that in. So at that time, it would have been on the same time frame as the 5-year licensing review, which is required by Section 4, is it? Let me just bring the table of contents up. It would have been statement of license policy within Section 5, which would require a 5-year review. But since that new Section 5A was brought into force, that requires a separate review of the cumulative impact alone every 3 years.
Yes.
And because that was undertaken in 2018, then the next review would have been due in 2021. Because that review didn't happen, then my advice has been that the steps taken to carry on the policy haven't been taken and therefore cannot continue the policy.
Well, I think we'll have to disagree on that. As I just to reiterate, there is nothing in the licensing statement that says that, and there is nothing in the Act that says that. And I would have thought, as the local authority whose duty is to protect the public of Swansea, a precautionary principle should be applied, and where there is a failure of the authority to review the policy, then the policy should roll over until the relevant consultation and review is undertaken.
I disagree because it's Section 5A places a mandatory 3 years to do that.
But it does not say that it falls away. The policy falls away if that is not undertaken.
the Act doesn't explicitly state that, but it does state what needs to be done in order to continue it. And if those steps aren't taken, then in my view, the Act implies that the Act doesn't, the cumulative impact policy doesn't carry on.
With respect, I don't think it does imply that.
Okay, well, I mean, that's the advice that I've given. If I'm wrong in law, then obviously there are higher courts to put me in my place.
Okay, yeah. We'll clearly agree to disagree on that point, but it'll be for members to obviously consider that and debate in due course. If I could just go back to the merits of the particular case. Bear with me, I've just lost my place now. It's critical to ensure that there is an appropriate mix of uses in streets like Wine Street, and late night premises such as this are more often than not closed during normal working hours, only opening during the evening and early hours. And in this particular case, of course, it's the premises isn't opening until 4 p.m. So for the vast majority of the day, it's closed and is an inactive premises. Where there's a continued build-up of such premises, streets become increasingly dead and uninviting during the day, leading to a general decline in positive activity and a rise in antisocial behaviour. If the authority does not enforce its own cumulative impact policy, and I appreciate we've debated whether that is applicable or not, then Wine Street could become dominated by late-night food premises and could quickly become Swansea's very own version of the quite infamous Caroline Street, also known as Chip Alley in Cardiff. The authority needs to continue to resist premises such as this in the interest of encouraging a diversity of mixed uses and, importantly, active uses that encourage daytime activity. A failure to do so could lead to a snowball cumulative impact and the deterioration in environmental, economic and social vibrancy in an important area which, we should add, is also a conservation area. It is unclear from the submitted applications what proposals or assurances were given by the applicant to overcome this very strong policy position, which presumes that new premises licences should be refused. And notwithstanding, it is very difficult to see how a new late-night kebab outlet would not exacerbate existing issues, which gave rise to the need for the policy in the first place, and indeed why it was being reviewed and renewed on multiple occasions. The application does nothing to demonstrate it will not lead to increased levels of activity in Wine Street area between 1100 hours and 0500 hours. The presence of new licensing activities will quite clearly result in additional activity. It will quite clearly provide another outlet that persons can attend for late night refreshments, and thus it will quite clearly lead to increased incidence of the common problems associated with such premises, including crime, disorder and public nuisance attributable to customers of such premises, which can include, but is not limited to, litter, noise, intoxicated persons, customers lingering for food, contributing to crime and disorder, continued accumulations of people at certain times, leading to conflict in queues for taxis, and the numbers of people leaving all types of premises at certain times. It has not been demonstrated that the new premises will not lead to an additional cumulative impact, when quite clearly, if you were to grant a licence for a new facility, it will encourage more people to attend, to linger, and it will take longer for them to disperse, quite possibly long after 5 a.m. My clients are established, responsible business owners in Wine Street that are clearly concerned that the presence of an additional late night premises licence will have a cumulative impact, which in turn will have a negative impact on crime and disorder, public nuisance and public safety, thereby threatening their staff and customers. On this basis, my clients maintain their objection to the application because the proposal will very clearly undermine 3 of the 4 licensing objectives, which the authority's own impact policy seeks to prevent, namely the opening of a new premises licence for late night refreshments, which will only encourage more late night activity in this area and will do nothing to prevent crime and disorder. It will undermine public safety and it will exacerbate public nuisance. the authority proceeds to grant this new premises licence, we believe it will be contrary to the Act. It will be in ignorance of the Council's own approved and adopted policy, in that it has failed to demonstrate how a departure from the policy is justified, particularly given that there has been no lawful revocation of the CIP, and it would represent a failure of its duty to protect the public against crime and disorder, public nuisance and safety. We therefore consider that this application should be refused, and any decision to the contrary could quite rightly be subject to legal challenge. Thank you.
I've no questions. Members of the committee, if I can just tell you something about the application. I know we've heard some things and you've seen the papers. By way of background then, so you know where we are. We're in 11 Wine Street. We're right in the centre of Wine Street. My client has taken a 10-year lease from these premises to open this flame. You've seen some photographs. So you've seen that he's already spent the money. He's equipped it and put in ventilation and fitted it out with everything that's required. It's been quite a large financial investment. It won't weigh on your application, but I'm sure you'd want to know. I'm told that he spent in excess of £100,000 on kitting it out. And the rent from Coastal Housing, they granted the 10-year lease, that's at £18,000 a year. So it's not fly by night. He's put a lot into this already. In discussing the application with Mr. Al-Saab, he describes the operation to me as a Middle Eastern barbecue and grill. I'm sure that's right. It's a kebab shop. I mean that with no disrespect. I would recognise it as a fairly traditional kebab outlet. What my client tells me is that earlier in the hours, before the early hours, so to speak, he intends and anticipates that there'll be rather more in terms of sales of ribs and chops and things like that. And I think you've seen a menu. I'm sure I filed a menu at some stage together with the photographs. But the probability is later in the evening and early in the early hours, the demand will be as a kebab outlet. And of course, that's been tried by him. We've had some 10s. We may have seen the reference to it in the letter of representation, which is on page 32 of the bundle, where Mr. Davis tells you about the track record and what a bad track record we have because we opened without a license. Well, we didn't. We opened and opened and operated under temporary event notices. And when we've opened and operated under temporary event notices, that's what we found, is that later on, traditional kebab outlet. You've heard about the recent past of these premises. So it was Tino's for some time. We think it stopped in about 2018, in fact. So that's pre-COVID, shut down organically, so to speak, rather than being forced to shut down. And the intention now, you've heard, is to ask for a license so that we'll be permitted to be open to trade between 4 in the afternoon through till 5 o'clock in the morning, 7 days a week. Whether it'll stay open throughout all those hours, that remains to be seen. Wine Street is not what it once was. I'm sure that everyone in this room remembers when Wine Street had Cafe Devro and a couple of banks, and that was about it. Oh, and there was the no sign. There wasn't much down there, and then of course it became this thing, and we couldn't work out whether we created a monster or something wonderful, but it became a bit of a monster for a while, and it was of course massively busy. It's not like that now. It's not seeing those glory days, if that's the right description, as was the case once upon a time. But nonetheless, we've had a premises which has been shut for some time, and my client has come along and wants to open from these premises. You may have noticed when you read through the application, I didn't prepare the paper application in this case. I've come in relatively late. But when you looked at the paper application, there's no mention in there of a designated premises supervisor. And I'll be corrected by everyone if I'm wrong. My recollection is that it works in this way. You've got to have a designated premises supervisor. And then there's another bit of law that says, well, if you're going to sell alcohol, you're not. Then the designated premises supervisor could got to have a personal license. So I'm sure I'm sitting here talking to you that we need a DPS, and I can tell you that the designated premises supervisor will be Mr. Imad Al Sabu sitting on the right hand side of me, shaking in his boots, sitting on the right hand side of me. He has some experience. The concern today is not about his fitness, but you'll want to know. He has some experience. He has worked in kebab shops in Swansea. He's worked in them as well in the Netherlands. Don't know how much use that will be, but what happened was when he came from Iraq, he went to Holland or the Netherlands, and he was there, and he's got family there, and he's also got this connection in Swansea. So he has some experience over and above the temporary event notices experience. You've seen the plans to the premises, and you've seen the photographs, and I've told you something about how much investment has gone into this. You will also have seen, and I have to flag it up to you, what the response has been from the responsible authorities. And this, for the purpose of this application, it will be my submission, is of critical importance, because we have the experts, people whose full-time job it is to just focus on this area of activity. The experts have been consulted, and the experts are not concerned about crime and disorder. Police have not come forward with representations. That's massively important. Pollution control, environmental health, they've not come forward with representations. Hugely important. And I'll use these words now because I'll refer to them later on. I know that the absence of such input from the experts will weigh most heavily with you. In fact, it's a requirement that it weighs most heavily with you. This business about the special policy, massively interesting from my perspective. I don't keep a check of when the council renews its policies. I'm told about it after the event. I don't mind admitting that the first time that my attention was drawn to whether or not the cumulative impact policy was still in force was when I read the report. I don't mind admitting that I thought, fantastic, wonderful. Because of course, from an applicant's point of view, if you have the special policy in force, then there's a presumption against grant. Without that, it's not quite like that. So of course it suits me, doesn't it, that that policy is not in force. But the bottom line, of course, is that you'll deal with the application on its merits. And that's all I ask you to do. And you know, if we had the policy in force, and I prepared the case initially on the basis that the policy was in force, I was going to be asking you to deal with it on its merits, which is what you'll do. I'm not quite sure that it makes that much difference to your to the decision-making process today, because I know, and those of us who've appeared before you plenty of times know, you deal with every application on its merits. It's the way it is. As far as the policy is concerned, though, there's been some debate in relation to the legal status of it from your lawyer and from Mr. Davis. In my submission, your lawyer respectfully is right. What the law requires, and it's mandatory use of English, actually. It says the word must, I think, is in there somewhere. It says the licensing authority, where a licensing authority publishes a cumulative impact assessment, it must, mandatory use of English, like the word shall, not optional. It must before the end of each relevant period, consider whether it remains of the opinion stated in the assessment. Now, if that process had taken place, what your outcome would have been, I don't know. Not sure it takes us any further forward today, because I ask you just to deal with the application on its merits. And dealing with the application on its merits, you obviously supposed to take an evidence-based approach. I'm not sure how much evidence has been put in front of you today, but nonetheless, we've heard concerns. And what you will properly do is look for evidence that there'll be a negative impact, crime and disorder. There'll be a negative impact. There'll be more noise pollution. There'll be more problems down in Wine Street that you should have controlled. That's what, in my respectful submission, as part of the presentation, you would properly be looking for. And if there was evidence of such concerns, if the police had made representations about crime and disorder, I would be applying my mind to how do I deal with those concerns that have been evidenced before you. Well, there haven't been any. There is no such evidence before you. What's said is, quite clearly, as emphasised a number of times, quite clearly there'll be additional problems with litter and noise, and it'll encourage more people. Well, let's deal with the last one first, encouraging more people. I love the idea that my client opening a kebab shop, I say that with no disrespect, my client opening a kebab house on Wine Street will lead to an influx of additional people using our famous Wine Street. I love the idea of that, but frankly, it's farcical. Do we really think that there'll be one extra customer in Wine Street if he's given this license? Might be me going down to have a free kebab, but over and above someone like me taking such advantage, are additional people going to rush to Wine Street because there's a new kebab house there? We won't go home early tonight. We'll stay in Wine Street for a bit longer because Flame has opened. Really? With all due respect, it's farcical to suggest that that might be the case. I'm sure my client wishes it was the case, but it just ain't going to happen. Fact of the matter is, we know, we can reasonably conclude that the trade that takes place in Wine Street is going to be the exact same trade that's taken place already. There'll be no additional customers. There'll be no additional litter. There'll be no additional accumulation of people. So where's the negative cumulative impact there? I can't find it, and I've been looking for it because, of course, I need to be concerned about these things. I need to address you in relation to these things. I just can't find it. In fact, on the merits, I would submit the reverse. Because what you've got now, and remember the guidance that we were all given by the Secretary of State, the build-up of people live queuing, fast food restaurants leads to problems. Remember all that guidance we were given? Well, there'll be less queuing. There'll be less people waiting to be served their kebab because we've got another outlet for them. Which, in my submission, when you look at the application, is going to be a well-regulated, well-managed premises. You've seen in the application all of the measures which have been listed in the application. Good job, whoever did it. I didn't do it. To address the licensing objectives. So you see, we've got full CCTV. We've got an SIA door supervision policy. We've got a maximum of 30 people in there. And you've seen the pictures of it, loads of room in there, loads of good access. We got any external seating being cleared away at 11 o'clock. We got provision in place to protect children from harm. We got it all really. And we've got it all in place because it's a good application on its merits. So if we were into the need to address cumulative impact saturation policies, I'd be saying, yeah, do it. Take it into account. And of course, you can take it into account, and respectfully, you should take cumulative impact matters into account. The guidance makes it clear that if a representation has been raised which talks about negative cumulative impact, then special policy or no, you as a committee have to take it seriously and have to take it into account. So I ask you to take it into account. I ask you to listen carefully to what Mr. Davis says, but then approaching it on an evidence-based or in an evidence-based manner. Where's the evidence? What we have here is a trade objection dressed up as a trade objection. And in the good old days, before the Licensing Act, I would have been on my feet in another place, in a magistrate's court, probably against a lawyer, saying there's no need for this, there's no demand, and we'd been arguing, that's what this is about. And this business is about additional pressures on Wine Street. There's sort of QED going on here. What everyone knows is there's going to be, if we open up, there's going to be a little less trade for everyone else, not more trade, a little less trade for everyone else. Where's the negative cumulative impact there? Unless, of course, and this is one that used to be used, not in kebabs, used to be used when we did betting cases and need was important, and we would say, well, if you've got too many bookmakers, they'll be enticing people in, you know, to bet in a way that they shouldn't. They'll be advertising, because you didn't used to be able to advertise, and now they're on the telly every night. But can we use such arguments in relation to kebabs? So if we open Flame, maybe someone else is going to have to put the prices down. There'll be more kebabs consumed at less cost. Is that really such a bad thing? Of think I probably ought to address very briefly. I'm finishing, I promise. I think I probably ought to just look at the matters that are raised in the representations. So could I invite you to go to page 32 of the agenda document? This is Mr. Davis's initial letter. I have got that right, haven't I? Yes, Mr. Barry Davis's initial letter. I'm just going to ask you to tick them off, really, so that, you know, they've been raised and I've addressed them. So it talks about the background and we were operating without a license. Well, no, nothing in that. Temporary event notices were in place. Talks about our track record. So we can, in my submission, you can ignore that. Talks about, therefore, we can't be trusted. Well, we don't think that's appropriate. Then door supervision. Well, there's door supervision provision within the license. CCTV, full, all singing, all dancing, CCTV condition within the license application. And then cumulative impact. If I go on about that again, then you're going to become tired of me. So I won't say any more in relation to that. Food hygiene rating, well, it's not been rated. Waiting for it to be rated. And I think, respectfully, that is about the size of my application to you. Thank you. Thank you. Not at all.
Not been, I understand what you said, but just to be absolutely clear, the CLA has lapsed. Is the authority under any obligation to advertise the fact it's actually lapsed? This is just to be clear now.
I'm not aware of a positive obligation to advertise the fact. Of course, I mean, it's a matter for individual hearings, not necessarily the general public, to be made aware of a. I think there's a requirement to advertise when in place, but not vice versa.
Sorry, is there an opportunity to come in just on that point? What I would say on that is that by the policy, by section 6 of the licensing statement effectively being disapplied, you are making a change to the licensing statement. The Act is very clear that where revisions are made to the licensing statement or to the CIP respectively, the licensing authority must publish a statement of the revisions or the revised licensing statement or the CIP. That hasn't been done. Nowhere on the local authority's website does it say that the CIP, cumulative impact policy, has been disapplied or is no longer relevant. That is contrary to the Act. And I'm very clear on that. And I think that's really, really important.
From Escape that had actually happened, so you were aware.
As Mr. Parry pointed out, the first we knew that that the authority had made any indication that the policy was no longer relevant was in the own papers, and those papers were written very much in support of this application. I've got to go back to section 5 and section 5A of the Act. It's very clear. If this authority is proposing to make changes to its licensing statement, which is what has happened because you've disapplied section 6, which is the cumulative impact policy, it must publish a statement of the revisions or a revised licensing statement, and that hasn't been done. When you look up the licensing statement on the local authority's website, it includes section 6, the cumulative impact policy. So it is our submission that that still applies.
I just, my view is obviously that is another breach. However, I don't think that disapplies my legal advice previously. But I accept what Mr. Davis says, that there is a requirement to publish any revision. So perhaps my advice regarding advertising was slightly incorrect, but I stand by my position in respect to the lapsing of the CIA.
None. I've no questions for anyone at all.
I've got no further questions other than to just reiterate that we very strongly feel that the cumulative impact policy does remain in place, because there is no mechanism for that to be revoked unless the local authority have consulted on that, and you haven't. So I think there's clearly a risk there to the authority. And where that cumulative impact policy remains in effect, that very clearly says that there should not be any further premises like this. That is the very reason that this same committee put in place that policy, was to prevent small incremental changes, cumulative changes from happening that over time change the character of a street. And that is why the policy was put in place. There is no evidence to say that that policy should be disapplied. And our view very strongly is that policy section 6 of the license statement still applies. And therefore, on that basis, your policy is that this should be refused. And thus, if you were making a decision today, our view is that you would be making a decision which is contrary to your own policy.
I think we've got a 5-day window to make the decision. It's likely that the decision won't be released today, but in any event, that will be taken into consideration.
I get the last word, which is which I always enjoy. In terms of close, I'm not going to repeat the application. You've only just heard it. You'll deal with the application on its merit, policy or no policy. If the cumulative impact policy was in place, you're required to deal with the application on its merit. If the cumulative impact policy was in place, you don't refuse every application. That's not what happens. You deal with the application on its merit. And if the police and the pollution control, they put evidence in front of you, go, well, you know, the presumption is we're going to refuse, and this is why, and you refuse it. That hasn't happened. Massively important. I put in the bundle this case of Thwaites, and I know that your chair is very familiar with this case of Thwaites, because at one time, this was like my American Express card. I didn't leave home without it, because I was referring committees to it left, right, and centre. It's important. I give you a brief bit of background. I'm not going to take you through the entirety of the case. In the Thwaites case, there'd been a decision made by a committee, appealed that to the Magistrates' Court. Magistrates' Court had refused an application, basically. Refused an application based on concerns about crime and disorder. That's basically it. And then the person who was aggrieved by that decision, they took this up to the High Court for a judicial review, and it's a lady High Court judge who gave a masterclass in licensing in this case, where she said what should have been taken into account, what shouldn't have been taken into account, and what the approach should have been. And in that case, it was the position the police did not express concerns about crime and disorder. And the magistrate said, well, we're concerned about crime and disorder. We got local knowledge. We're refusing your application, on which to that effect. And it was that principle that needed to be looked at. And it's made, at the time, it made new law. It's still law that's binding on all of us in this area. And what it tells us, what this case tells us, is that, and if I could invite you to go to page 53 in your agenda bundle, and it's in fact at paragraph 55, which I'm just going to take you to. It says it's clear from the guidance that drawing on local knowledge, at least the local knowledge of local licensing authorities, is an important feature of the Act's approach. It's not actually these words that I want to take you to, but to put it into context. There can be little doubt that the local magistrates are also entitled to take into account their own knowledge, but in my opinion, they must measure their views against the evidence presented to them. If I can pause there for a moment, I'm reading out here the words of the High Court judge. In some cases, the evidence will require them to adjust their own impression. This is particularly likely to be so where it is given by a responsible authority, such as the police, because they are the experts. They must also scrutinise their own anxieties about such matters as noise and other types of public nuisance, particularly carefully if the responsible authorities raise no objections on these grounds. That's where we are here today. The experts are not coming in front of you with evidence and saying on an evidence-based approach you should refuse this application, you should apply your presumption when you deal with this case on its merits. It's not what's happened here. Can I take you then, please, to page 55, still on this Thwaites case. It's the last short passage that I'm going to take you to, I promise. And it's midway down paragraph 63. And it says, however, in my view, their approach to what was necessary was coloured by a failure to take proper account of the changed approach to licensing introduced by the Act. Now, can I just pause there for a minute? Madam Chair, you'll know straight away, the test is not necessity any longer, it's appropriateness. So at the time that this case was decided, it was necessary, but now it's appropriate. The following words, still of very important application. Had they had proper regard to the Act and the guidance, they would have approached the matter with a greater reluctance to impose regulation. They would have looked for real evidence that it was required in the circumstances of the case. You change that now to appropriate in the circumstances of the case, because the legislation has changed to what's appropriate. Their conclusion that it was so required on the basis of a risk of migration from other premises in the vicinity was not one to which a properly directed bench could have come. These are the words. The fact that the police did not oppose the hours sought on this basis should have weighed very heavily with them. In fact, I misquoted her, didn't I? I realised now earlier on when I was referring to this or telling her I was going to refer to this, I say most heavily. It's supposed to weigh with you very heavily. Whereas in fact, they appear to have dismissed the police view because it did not agree with their own. So where that leaves us in the context of this application is that it's part of your responsibility to have it weigh very heavily on you that the experts are not coming in front of you with evidence as to problems with crime and disorder, public nuisance, or risks of negative impact in relation to those licensing objectives. And seeing as I'm on the big screen and I got my microphone on, the temptation is to continue, but I have nothing further to say unless there's any question that I can answer.
Thank you all for attending this morning. We're going to go into recess now. You will get the result within 5 working days. So the officers will be in touch with you with regard to that. But all I can say is thank you for attending this morning. It's been most interesting. And you'll hear from us in due course. Thank you.